Nuisance falls into three main categories: private, public, and Rylands. Private nuisance affects only a particular person or group of people. What constituted a nuisance was developed in St Helens Smelting Company. A nuisance was material injury to property or something which caused sensible personal discomfort. An important adage was that a nuisance cannot be something which was necessary for the legitimate and free exercise of the trade. The nuisance must also be ongoing. One-time damage is not a nuisance. Remoteness principles also apply to a nuisance claim. It must be reasonably foreseeable for the defendants. For a person to claim for nuisance, they must also have an interest in the property. The important case of Coventry v Lawrence contained 5 key rulings. Right to commit nuisance can be acquired by long use. If the claimant uses the property for the same purpose as the predecessors, then the defendant cannot claim they came to the nuisance. In assessing character of locality, nuisance-causing activities are to be entirely discounted. Planning permission does not mean relevant activity is lawful. The courts may decide whether to award damages and/or an injunction. To pursue an action, the claimant must have an interest in the property. This can be as an owner, occupier, or licensee. In private nuisance, occupiers can be liable for the actions of trespassers if they continue the nuisance. A public nuisance arises when a nuisance affects Her Majesty's subjects rather than a particular person. It interferes with the interests of the community. Rather than protecting property interests, it protects publicly held rights. One important distinction between private and public nuisance is that personal injury can be claimed for under public nuisance. Rylands v Fletcher concerns a case where the defendant had placed a reservoir above a disused mine which he was unaware of. The water filtered through the disused mine and damaged the claimant's working mine. Although there was no negligence, the court ruled that in this specific type of case, the liability became strict. 5 factors must be satisfied to determine if the case is of a Rylands type: accumulation, mischief, escape, non-natural use of land, and not too remote. The rule in Rylands has been clarified over time. It does not apply where a deliberate act of another has caused the damage. The remoteness rules are still very much at work. A fire does not count as unnatural, and the use of land must be extraordinary and unnatural.